morning, everyone. For those who didn't attend yesterday, I'm Gergely Dobozi, Senior Research Fellow of the Danube Institute. Unfortunately, my colleague David Odor-Bolt, the charming Englishman from yesterday, got sick. So this morning I got to know that I have to secure the crime scene. Now, if we get over together my Central European English accent, we might have fun together. But to adapt a more serious tone, yesterday we had magnificent lectures and terrific panels, and I'm sure taking a look at the lineup for today, today is no different. So let's start day 2 with the keynote speech of Professor István Stumpf, former Constitutional Justice of the Constitutional Court of Hungary, former Minister for Chancellery in the Hungarian government, and now the Special Advisor for the Prime Minister. Mr. Stumpf, the floor is yours.
Good morning, ladies and gentlemen. Thank you very much for the invitation, and I hope we could manage the very fruitful conference today. The topic is the ideal concept of the rule of law. Let me allow that at first I would like to talk about the discussion about the rule of law and this kind of landscape. The rule of law is the fundamental concept of the governance and also the statecraft, and universally recognized norm among the democracies. It is also essentially constituted concept. There are constant debate about what does entire or what is should entire. Today, the only agreement among the legal scholars about the rule of law that is there is a disagreement about what is actually mean. Francis Fukuyama argued that the three most important elements of the political development in the history of mankind were the state, the rule of law, and the accountability. According to him, the principle of the rule of law has its origin in the religion, which was able to create a set of rules independent from the state, its legitimacy. For the contemporary political science and constitutional law, question about the state, the rule of law, and the accountability and the relationship with each other still among the most interesting topics. It is the last decade discussion about the rule of law have become the part of both of the political agenda on both sides in the Atlantic. Both sides of the political spectrum make accusation regularly against one another for a lack of respect for the rule of law. Let's see some examples. In the US context, the election integrity has been one of the continuous topics of the last few years. Election integrity, it seems by many as important products of the rule of law. Voter ID laws and regulation, the legal status of the mail-in ballots, the ballots harvesting are all considered to be a most important rule of law issue. We all saw that what happened with the mail-in ballots in 2020. And suddenly, there is no guarantee of not happening this year again. The rule of law is especially important in election integrity, and since the election are the cornerstones of the democracy. In Europe, the discussion about the rule of law revolved around the judicial independence, civil society, media freedom, particularly in Hungary and Poland. Coincidentally, these two countries also happened that the electoral conservative government with a vision for Europe that is drastically different from the Brussels mainstream. We are away from what could be considered reasonable and even further away what should be the ideal. To arrive at a meaningful solution, first we need to understand the problem is its entire problem. That is the long road we can get together to conceptualize that. The conceptualization, how an ideal concept of the rule of law should look like, we need to specify the issue for our current situation. The rule of law clashes as a cultural war. The global elite worldwide, and the Eurocrats in particular, all have one thing in common: an aversion to the national sovereignty and the national identity. This is, of course, not new, but clashes. Today, we are living in an age that is similar to what Reinhard described in the late 70s in his monumental work, The Silent Revolution. The society worldwide are experiencing similar deep structural changes with a significant cultural shift resulting from this phenomenon. In the last decade, we have seen the conservative forces gaining grounds applying the national sovereignty notions. The Brexit referendum was framed by the UK conservative as taking back control. Donald Trump was elected in the US presidency by using Make America Great Again. The national identity has become the focus point of the political battle worldwide. Europe is struggling for an identity. In the recent decade, Europe has lost its role experimental in the model of innovator. The overgrowth of EU bureaucracy, alongside in the sidelining of the national interest, has created a background power system lacking democratic legitimacy. This system is almost exclusively interested in establishing the federal structure above the member state. What we are really experiencing today in the fact not a crisis of constitutionality, but the crisis of identity. The debate about the rule of law are, in fact, the debate about the different value system. This is a war that is being fought on the grounds of sovereign nation state versus supranational conception of statehood, sovereignty, and democracy. The weaponizing of the rule of law is an important instrument in the globalist crusade against the nation state. What is the weaponizing of the rule of law? The lack of consensus on the definition and the substance of the rule of law makes it a perfect weapon for its ill-intentioned violers. The rule of law means whatever the liberal values they want to promote, and the disagreement in said values invites and attacked. Accusing the EU member state of the rule of law deficit is a way to mask disagreement of the values in the legalistic manner. It describes the opponent on the basis of lack of respect of fundamental norms of governance. The most important aspect of the phenomenon is the politically neutral appearance of the rule of law debates. By maintaining the facade of the legal argument, there is no way to showcase different values and ideas, a vision for Europe alternative to the Brussels mainstream. The principle of the rule of law thus become the partisan tool to whip into the line those who think differently about the future of European community. The ideal concept of the rule of law, the concept is the result of the evolution of the European legal and political thought. It is a fundamental concept of the governance, one that we should cherish and embrace as a part of modern democracy. The debate about the rule of law cannot be separated from the debate about the national identity and the national sovereignty. Thus, is an ideal concept of the rule of law should be approached from the sovereignist perspective. The concept of the rule of law needs to return to its original meaning, stripping it from all the recently added context and secondary meaning to the term. The misuse and abuse of the term needs to stop. It is not the idea that is wrong, it is the deceitful carried put on by the globalists to the further weaken sovereign nation states. From the sovereignist standpoint, we need a rule of law conception that does concede any authority over the domestic affair to the supranational organization and international bureaucracies. The Eurocrats instrumentalized courts to promote their federalist agenda through seemingly the natural ruling about the rule of law. The sovereignist approach to the rule of law should also include the protection of the national court authority. We need the rule of law conception to protect the national constitutional identity. The globalist agenda involves the weakening of the state institution, undermining the nation's ability for self-determination. The weaker our national political institutions are, the more dependent we become the supranational organization and global structure. We need to safeguard our national political institution from any efforts aimed at undermining them. I have some experience as a constitutional justice. There was a big conference organized by the Constitutional Court in Hungary, and we invited the president of the European Court. And there was a huge debate about who is going to say the final word if the European regulation conflicting with the nation-state constitutional regulation. I am as a sovereignist saying that if there is any conflict between the European regulation and the national constitution identity, the final word should say by the Constitutional Court, the National Constitutional Court, because this is the constitutional issue, not the general issue which is going on in the European Union. It is this kind of discussion is going to increase, and the next month there will be the trilateral committee meeting in Brussels, which is an interesting group of people, and this will be the first time when the trilateral organizer inviting justices. One of the judge, that kind of guy who is the president of the European Court, and they also invited the justice of the Belgian Constitutional Court. I am wondering, I'm going to participate in this meeting, I am wondering what will be the discussion about that. But following one of the last major decision of the German Constitutional Court, which said that the European Court decision was unconstitutional according to the German Constitution, and that's a very pioneer decision, and I hope that the Hungarian Constitutional Court, if we are going to make this kind of challenge, we are going to make a right decision. Thank you very much for your...
Professor Stumpf, thank you for your valuable insights. Now, as we move forward, let me give the floor to Professor Dr. Reinhard Merkel from the University of Hamburg, who's currently the visiting fellow of the Matthias Corvinus Collegium, also the member of the German Ethics Council and a member of the Freedom of Science Network. Thank you very much.
Thank you. So, good morning, ladies and gentlemen. Let me make two brief remarks before my talk. I am a legal philosopher, and that's my only competence in this context. So what I'm trying to convey to you is an analytical approach to the basic notions in my title. Rechtsstaat is a German expression that has no translation into English, and as far as I know, into any other language. That's a German-coined notion. And my second remark before my talk is that I actually put most of what I'm going to tell you on those slides in order to more or less keep within my time frame. So let me begin. Basic conceptual issues. Rechtsstaat. I'm going to stick to that notion as it is not translatable into any other language. Both terms contained in that concept are complex and controversial in various respects. Immanuel Kant formulated highly abstract definitions for both. A state, he says, civitas, is the union of a multitude of people under legal laws. And law is the sum of conditions under which the choice of one can be united with the choice of another in accordance with a universal law of freedom. Rule of law obviously contains no explicit reference to the state. This marks an obvious factual, but not a normatively essential difference to the concept of the Rechtsstaat. Now, abstract objectives of the principle of Rechtsstaat and of the rule of law. Primary concern of the Rechtsstaat is, according to Friedrich August von Hayek, the comprehensive legal binding of the exercise of all state power. John Locke, one of the important intellectual fathers of the idea of a rule of law, formulated its basic aim in a similar way. For all the power the government has being only for the good of society, as it ought not to be arbitrary, so it ought to be exercised by promulgated and established laws, that both the people may know their duty and be safe and secure within the limits of the law, and the rulers too, kept within their due bounds. Now, on the basis of the same fundamental principles, I will delineate some differences of specific conclusions from these two fundamental concepts. Rule of law, its normative content can be spelled out in three elements. Absolute dominance of the formal law over any influence of arbitrary decision-making power of the government. Equality of all before the law. This includes prohibition of any legislative and jurisdictional power of the administration. And third, the ultimate point of reference for all law is the free citizen. The rule of law thus stands as a short formula for the fact that the law of constitution are not the source, but the consequence of the rights of individuals. That's the definition given by Albert Dicey, one of the major English legal philosophers of the last century. Rechtsstaat, as opposed to what I just said about the rule of law. Today, one regularly distinguishes between formal and material conditions of a Rechtsstaat-based constitution. Legal positivism, such as Hans Kelsen's, the famous Austrian legal philosophers, however, rejects a concept of the Rechtsstaat based on normative content. Famous sentence, I'm quoting a famous sentence from Kelsen's Reine Rechtslehre, Pure Theory of Law. Therefore, any arbitrary content whatsoever can be law, good or bad law, of course. Different, however, seems to be our Article 20, paragraph 3 of the German Constitution, the German Grundgesetz. Legislation, it says, shall be bound by the constitutional order, executive power and their judiciary shall be bound by legal statutes and by law. And by law means bound not only to formal law, but also to its fundamental principles. Now a word on what I want to call the dialectic of the idea of the Rechtsstaat as well as of the rule of law. In general terms, Rechtsstaat therefore means the ideal of a state in which the limits of state power are defined and guaranteed with regard to the individual freedom of citizens. This primary concern gives rise to a normative tension. The power that is necessary for this protection of civil freedom must at the same time and for the sake of this freedom be limited, that is, legitimized as well as confined for the state as the holder of this power. The question of what exactly the power of the state is bound to and how this binding is to be realized is a matter of debate, of course. But the fact that it is bound qua Rechtsstaat is directly applicable law in many modern constitutions, not only in the German Constitution. Now, a few words on the formal concept of Rechtsstaat, and you may just add, and the rule of law too. Separation of powers, of course. This is the core of the formal concept. Its primary purpose is first protection against the monism of power as a total concentration of power. And second, subordination of the executive to the legislature. 3 corollary principles can be derived from this. Legality of the administration. That means first, primacy of the law, and second, proviso of formal law, no intervention without authorization by the law. Second, guarantee of legal protection, that is, a claim to legal judgment. That is simply the flip side of the state's monopoly on the use of force. And third, guarantee of legal certainty, that is, the predictability of state interventions. First, sufficient determinacy of laws. Second, consistency of the legal system. Third, retroactive effects of laws are only permissible within very narrow limits, not permissible at all, for instance, in the criminal law. That is, protection of the legitimate trust of the citizens. Now, the more important thing may be the material concept of the Rechtsstaat. These formal characteristics are only necessary, not sufficient conditions for an efficient Rechtsstaat. They need to be supplemented by a substantive concept encompassing, above all, the guarantee of fundamental rights, that is, human rights transformed into constitutional law. Second, the principle of proportionality of all state measures. This means prohibition of excessiveness when interfering with the rights of citizens, and prohibition of disproportional undermatching, so to speak, in the protection of these rights of the citizens. Now, from this, certain conflicts can arise. The principles and elements of the Rechtsstaat can lead to normative collisions in two respects. I want to call them internal collisions, above all between the principle of legal certainty and the principles of justice. They can conflict. Legal injustice, that raises the question, is there such a thing as a legal injustice? And is there such a thing as a supra-legal right? Legal positivism versus natural law. That's an age-old debate, actually beginning in Aristotle, in the Greek antiquity. Civil disobedience, and the next collision, possible collision. In a constitutional Rechtsstaat, is there such a thing? Can it be justified, civil disobedience? Is there even a right of resistance? I would say not in a true Rechtsstaat, but civil disobedience might be a different thing. And the second topic I want to call external collisions of the entire concept, so to speak, of Rechtsstaat with other constitutional principles, especially that of democracy or political principles of state, such as that of sovereignty. Such collisions must be resolved by elaborate methods of weighing in each individual case. And now let me, from this, what I just said, point to the limits of Rechtsstaat as well as of the rule of law. And I want to give you an example, well, to illustrate what I want to say. All the world knows this picture. The second plane, a moment before crashing into the second Twin Towers. A few years later, on January 11th, in 2005, the German legislature passed the Aviation Security Act, ASA, by a large majority in our parliament. It came into force on 15th of January 2005. Now, the relevant norm is Section 14 of this ASA, Operational Measures Authority to Issue Orders. First paragraph. In order to prevent the occurrence of a particularly serious accident, the armed forces may force aircraft out of the airspace, force them to land, threaten the use of armed force to fire warning shots. And then the third paragraph, the direct use of armed force, the shooting down of the hijacked plane, is only permissible if it can be assumed from the circumstances that the aircraft is to be used against human life, and it is the only means of defense against this present danger. Now that points to normative limits of state power in a Rechtsstaat and of the rule of law too. Here's the verdict of the German Federal Constitutional Court on that Section 14. In its ruling of 15th of February 2006, the Federal Constitutional Court, Bundesverfassungsgericht, declared Section 14, paragraph 3 of the Aviation Security Act to be unconstitutional and null and void, due to its violation of Article 1 of the German Basic Law, Protection of Human Dignity, and Article 2, paragraph 2, Right to Life. The decision is binding for all state bodies in Germany, including the parliament. But is it correct? Actually, my American colleagues that's my experience, tend to say, "You're crazy, you're Germans. Such a plane, if it can be shut down, must be shut down." Well, our Constitutional Court said no. And I'm posing the question, is that no correct? In my opinion, it is. I don't have the time here to analyze the complicated issues in detail. Let me just outline the basic arguments. Collisions, question mark. In cases like 9/11, 3 different collisions of the concept of Rechtsstaat and the rule of law become recognizable. First, what I called internal collisions, protection of the lives of the people in the Twin Towers. Nearly 3,000 people were in there, versus prohibition of the state killing innocent citizens who are victims of a crime too, with a fundamental right to life in the aircraft to be shut down. There were around 200 people in that aircraft. And now an external collision, prohibition of the killing of the aircraft occupants versus protection of democratic principles, enactment of laws by the parliament, as it was done in Germany. And the second external collision, prohibition of killing of the aircraft occupants versus protection of state sovereignty against attacks of foreign terrorists. The basic arguments for a solution, just briefly sketched. The premise, as a reminder, is Rechtsstaat as well as rule of law are shorthand expressions for the fact that the law of constitution are not the source. The laws of constitution are not the source, but the consequences of the rights of individual people. The point of reference for all law is therefore the individual, the free citizen. Now, on my first internal collision, in the event of a catastrophe, such as 9/11, the primary duty of the state is not to save as many lives as possible. We all must die one day, but to warrant the foundations of the legal order. None of the occupants of the aircraft has a legal duty of solidarity going so far as to oblige them to sacrifice their lives in order to save others, even many others, 3,000 others, whom they do not harm, do not threaten, and may not even know. There is no such duty of solidarity. One of the famous American philosophers once said, his life in a different context, his life is the only one he has. And that's why no one is obliged to sacrifice that for reasons of solidarity for saving others. Hence, no one, not even the state, has the right to impose such solidarity on them and actively kill them for it. The death of the victims in the Twin Towers, because it cannot be prevented by legally admissible means, is therefore not attributable to the state, but solely to the terrorists. And now in the second collision, this also clarifies and settles the problem of a possible collision with principles of democracy. If the legal order, Rechtsstaat, rule of law, in a democratic constitutional state is ultimately there for the citizens as free individuals, and not conversely the citizens for the state, as Aristotle had it, then the state may not enact laws that, as general norms, would allow it to do something in general that could not be legally legitimized in any individual case. Now on the third collision, what appears to be far more difficult in such cases is the collision between the principles of the rule of law and the conditions of state sovereignty. Terrorist attacks, such as the ones on the Twin Towers, are not primarily aimed at the lives of their immediate victims, but strike at the heart of the state, so to speak, at its function as guarantor of the legal order. To discredit the state in this most fundamental task is their raison d'être. In doing so, they are attacking the state's sovereignty, its protective function for its citizens, and hence the precondition of its justification, overall justification as a coercive legal order. What they want to demonstrate, the terrorists, is that this protective function can be cancelled arbitrarily and be eliminated at will. Every time such an act of terror succeeds, the state would be discredited as defenseless in the face of terror, and thus as incapable of fulfilling its primary task. Ultimately, this would threaten its existence as a legitimate legal order. Each individual case of a serious terrorist attack, at least on the scale of 9/11, misspelling here, therefore constitutes a case of existential emergency for the state. For such an emergency, it may create regulations that allow it to kill innocent citizens in order to safeguard its own existence as a functioning state. However, such a potential authorization must then be included in the Constitution, so that it is clear to citizens that the state may exceptionally do something to secure its existence that it is normally absolutely forbidden to do, kill its citizens without any malfeasance on their part. The German Constitution, the Grundgesetz, contains no such proviso. Hence, the ruling of our Constitutional Court, the confiscation of Section 14, Paragraph 3 of the Aviation Security Act, was correct from the Rechtsstaat perspective. And here's the end. Gustav Radbruch, a famous German legal philosopher of the 20th century, once wrote, "Democracy is certainly a good to be praised, but the Rechtsstaat is like daily bread, like water to drink, like air to breathe. And the best thing about democracy is precisely this, that only it is capable of safeguarding the Rechtsstaat, the rule of law." Thanks.
Thank you very much. Oh, sure. Thank you very much, Professor Merkel. So let me move on to our thunderstruck panel, moderated by Ákos, Bence, my friend. One thing you have to know about this panel, that originally we planned it with another speaker. MEP Margarita de la Pisa-Carrion had to stay in Spain because of her campaign activities, and Eduardo Raffiota had to cancel it due to other reasons. But now we will have on the floor Daniel Scalea instead, and thank you very much for your openness to participate in the last hour. Shortly, I will introduce you because you are not in the program. Daniel Scalea is the co-founder and the president of the Italian think tank Machiavelli Center for Political and Strategic Studies. He is MA in History and PhD in Political Studies, adjunct professor at Cusano University of Rome and Marconi University of Rome. He previously worked as a consultant at the Italian Parliament and the Ministry of Foreign Affairs. And also, I welcome on the floor Gadi Taub, renowned historian and commentator from Israel. Thank you very much, and give an applause for them.
So thank you very much, ladies and gentlemen. Welcome on the floor, and I will enjoy the discussion after the short introduction speech. I am Ákos Bence. You have to know that I'm Head of Affairs at MCC Brussels. Previously, I worked at the Danube Institute as well, as Head of Foreign Affairs and Communications. And I'm also a researcher, and my main field of studies is the European policy on the rule of law. I wrote a book on this issue, several books with the translations, and a PhD thesis, so I am very much into this topic. I think that this conference is highly important. It's highly important that we organized today, and you are all here today. And this is not only a question of, I want to be polite to say so, because we usually say this. This is also the truth, because if we look a bit outside, we see that those political forces or those activist scientific forces who kind of monopolized the rule of law, the concept of the rule of law as a political means or political weapon, they organize such a conference every day. Minister Bóka János said yesterday, Minister of Justice, Minister of European Affairs of Hungary, that parallel to our conference, we had another conference at the CEU in Budapest, where they treated the question of the rule of law from a different perspective. And this is not only a coincidence, this is because we organized this today, but they organize such an event every day. So I think that we have to continue, and we have to organize much more series of conferences like this. It's important for all those who do not like the monopolization of the rule of law by one side, because they don't agree with because they don't agree with the framing they give to the new rule of law concept, because they think that the rule of law is a very important constitutional concept, such as it has been explained, and it's worth preserving it outside the political domain. So today I would like to... Thank you very much. So today I would like to give you a diagnosis of what is happening in Europe, and also I would like to advocate for an initiative. So you have to know, as a Hungarian, I experienced for a long time what is happening in the name of the rule of law. And if you look at the picture of European debates around the rule of law between mainly Hungary and EU institutions, you see that in the early 2010s, the political left of the European Parliament started to criticize Hungary for attacking the democracy, attacking the rules, attacking the rule of law, attacking European values. It was the political left. It is clearly demonstrable through the different acts of the European Parliament and the voting casts. Now, what happened is that the European Parliament put a lot of pressure on the European Commission and also on the Council to do something in the name of the rule of law, to kind of control EU member states in the name of the rule of law. The Commission, at the first time, they saw that they had no legal basis to do such a control, because if you are a bit familiar with the European institutional system and the European legal framework, you have to know that the Commission has a broad power of control over member states regarding the execution of EU law. However, those criticisms that they used against Hungary, they were not in the scope of EU law. For example, they criticized Hungary because of changes in the judicial system, or they criticized Hungary because it adopted a new constitution, and in this constitution we wrote that Christian traditions for Hungary are important, that people do not only have rights, but they have also, citizens have obligations. Or they criticized the constitution because they mentioned that, marriage is between one man and one woman. Back then, already in 2010. So basically, these were matters that was clear that they were outside the EU competencies. But there was much political pressure on European institutions from the political side. And the Commission came out in 2014 with the idea of a so-called rule of law framework. Now, the rule of law framework is a means in the hand of the European Commission to substitute the infringement procedures. The infringement procedure is the usual procedure that the European Commission can use if a member state violates European law. But since we are not speaking about violation of European law, but we are speaking about political matters, they are not allowed to use infringement procedures in short. So that they invented another procedure, which is called the rule of law framework, which had the exact same shape that the infringement procedures, but it was not called infringement procedure. And there was a difference at the end that it was not possible to include in the legal debate the European Court of Justice. Back then, the Council of the Member States, so the Council's legal service, issued a reaction, a legal analysis, legal assessment of the Commission's new tool, the rule of law framework. And the legal experts of the Council explained that what the Commission is doing is against the treaties, so the foundational documents of the whole European legal system. They said that what the Commission was doing with this act was against the legal basis. There was no legal basis in the treaties, it was illegal, and they even wrote that it is impossible for the European institutions to control the member states in the name of the rule of law, except for the Article 7 political procedure. Now, what happened is that, they sacrificed the legal, the rules of the European Union in order to reach a political goal, because the Commission simply did not did not react anything meaningful to this legal criticism of the Council. And back then, when I was discussing with some French diplomats, they told me that they were aware that this was a legal nonsense, but at the same time, they were also aware that politically they had to do something. So that is how the whole rule of law procedures inside the European Union started. And it was about this tool of the rule of law framework. It was political and legal pressuring, but without binding decision and at the end. But back then, a proliferation of rule of law tools started, and we saw the emergence of annual rule of law reports. So now all the member states are under scrutiny every year. These rule of law reports then are the foundations for other procedures where they want to take away money from the member states. There is the conditionality mechanism. Under this conditionality mechanism and other mechanisms, now Hungary saw kind of 30 billions of euros suspended. So there is an effect. There is a very important effect of what is happening in the European Union, even if basically it is against the rule of law, the very rule of law of the European Union. It is against the treaties. So the question that we can ask, how scientific people, experts, saw this question. Did they criticize what was happening before their eyes? And the answer is no. It's a huge no, because on the contrary, these were specific expert groups, think tanks, NGOs, who pushed the Commission and European institutions to go forward. So they kind of created the frameworks, they created the legal solutions creatively that they proposed for the European institutions. They suggested what they have to do, and it was really against, once again, the European rule of law, the European legal institutional system. So experts played a huge role in this, so-called scientific people. And that's why I think that it's very, very important that we stop this phenomenon. I think, and that would be an initiative that I would advocate for, I think that we should do much more gathering like this to discuss the foundational issues and debates around the rule of law questions. it is all the more important that it is not only a question in the European Union. It is not only a question for Hungary. It is not only a question for Central Europe, for Poland, other countries. It is also a question for Italy. It is also a question for Western Europe and the whole European Union. But it is also a question for the United States. It is also a question for Israel. So this is a global question. So I think that we have to act and we have to do something in order to preserve the very foundations of this very important constitutional concept of the rule of law. I think that we have to think about creative methods. We also have to know better each other and reference each other, because the other side, what they do is they are doing cross-references to legitimize their opinion. So I think we should do all this. We should consider a memorandum of basic statements of why we consider that the rule of law is important. We should consider to publish together in journals, why not to found something together. So I think that we have a lot of things to do. And that is why I'm very happy to go forward with this panel with two distinguished speakers, Gadi Taub and Daniela Scalea from Machiavelli Center, and from Israel, historian and political commentator. And I think that what happened yesterday and what we are continuing is we are going to look for case studies. We are going more deeply into what is happening in your countries so that we can collect some more facts to support our arguments. Thank you very much for your attention. And let's go for the panel. So thank you very much. So what we agreed previously is that we give the floor for you for both each of you 5 minutes to introductory statement, and then I can come with some specific questions towards you. So Gadi, can you start, please? Yes, please.
7 minutes, I think.
Okay, 7. There is freedom in this hall.
So, first of all, I'm thankful to be here, and I feel at home. And Bence's book is something that I teach my students from, because it's an amazing window into a general phenomenon, and not just into what they call the democratic deficit of the European Union. It's not a democratic deficit, it's an attack on democracy. It's not some byproduct of other processes. This is the process. The process is a process of transferring sovereignty from elected bodies to appointed bodies. It is happening all over the world. I'm sad to say that Israel is extremely innovative and much more advanced in this protest, and we are now formally a juristocracy. So there is a lot to learn from the case of Israel, but there are also some, as in all cases, some idiosyncratic elements, one of which is the role of the security establishment and the army. Now, this sounds like from another world, but it really isn't, because in the general phenomenon of transferring the centers of decision-making, that is sovereignty, from elected bodies to appointed bodies, the army is, generically speaking, one branch of the bureaucracy, and in Israel, a very strong element in the elites that are trying to preserve their power against democracy. So the general process is, I'm assuming, well known even outside Israel, so I just point to it in very general terms. The left lost power in Israel in 1977. Ever since, it has been transferring the centers of decision-making into the bureaucracy, and especially the Supreme Court. It met with very ambitious judges, a very bold judge who is now in The Hague, sitting at the International Court of Justice. And someone in Israel got it into their heads in our government that sending him there will protect Israel, instead of understanding that international tribunals are the continuation of the same process. It's not just something happening within the states where the centers of decision-making are transferred from electoral bodies to judiciaries, it's also transferring the decision-making outside the state, and this is not something I have to explain to Europeans because the European Union is the prime example of it, but it's not the only example, of course, because the tribunals in The Hague are of the same characteristic as our economic institutions and treaties and other international, and the UN, of course, and other international instruments which are subduing the state. So what has happened to us is we sent Judge Aaron Barak, Supreme Court Chief Justice Aaron Barak, into The Hague because people said they will respect him because he is like them and he'll be able to protect us. And guess what? He participated in 2 decisions against Israel. One of them will strengthen the Supreme Court of Israel against the other branches of government. So, surprise, surprise, Aaron Barak is not protecting Israeli democracy. This is after they've been telling us for decades that we should have a strong judiciary because this is what will protect us against international justice procedures. So it hasn't protected us one bit. We see this kangaroo court that is blaming Israel for genocide, for protecting itself, while Israel is conducting a war with a terrorist organization bent on genocide, and in an urban settings, and despite all this, the ratio of civilian casualties to combatants is the lowest in the history of urban warfare. The estimate is that it is between 1.7 and 3. This is the range of civilian casualties to combatants, as compared to the average by the UN, which is between 7 and 9. Civilians to combatants in other wars and in other areas. And this is with a terror organization that is attempting to maximize civilian casualties because it is indifferent to human life and it thinks it will gain advantage by having more pictures of dead babies, some manufactured by AI, some, of course, regrettably, actual babies. So we were supposed to be protected from procedures based on the assumptions that these procedures are somehow really legal and fair, while they are completely political, and this is a complete kangaroo court. So just less than a brief history of what happened in Israel, because we had an attempt at judicial reform. Simcha Rotman is here in this conference. He's not currently in the room. He'll be here later. He's the second most important player and has been waging a gallant war against dishonest opposition in the parliament. He heads the committee of the Knesset on constitution, law, and the judiciary. And they formulated the actual bills that were supposed to be the reform. So I don't have time to say, but we started very low. We started with the court that's the most powerful in any Western democracy compared to the other branches of government. It claimed for itself the ability to strike down laws and to interfere with any government decision, to annul any decision by the other branches of government. It did away with limits on standing, and it invented a new clause of reasonableness, which enabled it to strike down things that are legal based on the idea that they may be unreasonable. A lot of these decisions about striking down things for being unreasonable were a majority decision in the court. Apparently, there are some justices who are unreasonable. Otherwise, I don't know how to explain why there was no unanimous view of unreasonable things. You know from jurisprudence that the idea of unreasonableness is usually devoted to crazy things. If someone in Tel Aviv named a street after Adolf Hitler, then the court would say this is a decision that no sane person would ever think of and strike it down. Or if someone in Jerusalem municipality will declare that parking is forbidden all over the city, then that's completely unreasonable. But what they did is they enlarged this concept so that they call unreasonable any decision that they don't like, and they interfere with anything. And so we had the most activist court in the West. Well, so we thought. That is nothing compared to what we have after the attempt at judicial reform. I should maybe add a personal comment. It says in my bio that I was cancelled from Haaretz. This is probably the best forum to explain this, because I was cancelled in Haaretz. My column was shut down for 2 reasons. One is that I supported judicial reform. The publisher said that this is an opinion that is illegitimate and should not be heard. This is the opinion of half the population. It's illegitimate. Taub's opinions are illegitimate and should not be heard. And the second reason is that I'm an agent of the Orban government. Did you know that? Apparently, they found that I had a 2-week fellowship at MCC in which they portrayed me as a paid agent of fascism, you know. And I was there because I wanted to find out what is going on with the rule of law. I'll tell you. I came here because of the debate over judicial reform, and they kept saying we will be like Hungary. I came here to find out what Hungary really is, and this is how we met, Bence and I. And so the deal was that I give 2 lectures to their students, and in return I can sit with some professors of law and because I don't read Hungarian, understand generally what is going on here. So I wasn't paid, Ophir. I was giving a room in a hotel, but it was too small, and I didn't have room for my computer. So at my expense, I took another hotel so I can write down what I learned during the day as an agent of the Orban government, which they still say about me in Israel. It's just, I stopped answering them. It's just too ridiculous. So I supported the reform, and the reform failed. And it says in the annals of our press that the reform failed because there was an uprising of participatory democracy to defend us against the coming of they called it a messianic dictatorship, a complete fraud. And so the citizens stopped it from coming. It's not the citizens. The army stopped it. The upper echelons of the IDF made clear to the government, or I should say, refused to make clear to the elected government and the parliament that in case of a conflict, a constitutional crisis, that is, if the Supreme Court strikes down the reform that's supposed to reform the Supreme Court, what do you do then? That's, I guess, a question I should refer to Professor Merkel, because there is no I think, a legal solution to it. But the army and the police and Shabak, the security service, and the Mossad refused to say that in case of a constitutional crisis, they will take orders from the elected government. And they said, Bence, this is classic for you, they said that in case of such a constitutional crisis, we will obey the rule of law. The rule of law is the judges. That's what they said. So their concept of the rule of law is not the rule of law, because Israel has a basic law that says the army is subordinate to the elected government, period. And so they turned it on its head because the judges represent the law. It takes very low political literacy to accomplish this trick. But I suspect that this trick is at the basis of a lot of this stuff, because what is happening in Europe is that the rule of law has become the rule of courts. And this is the confusion in which our terms here are corrupted. So in the end, the reform failed because the minister who is in charge of the army, the Minister of Security, we don't call it Minister of Defense, we should start calling it the Minister of War. This is what it should be, but we have progressive generals. So the Minister of Defense, instead of suppressing the mutiny in the army, joined the mutiny in the army, and in a speech in which he pretended to worry for Israel's security, he said you can't go on with the reform because it's tearing the army apart, and this will cause the collapse of the army. So the end of the story is what? The reform was stopped, and then the war started. By the way, because of the same mutiny, I'll maybe have something to say in the Q&A about that. But after the war started, the very last bit of the reform, which was an amendment to a constitutional law, was passed in Parliament 64 votes against 0 because the opposition stepped out. The court struck it down in the middle of the war, which means now that the court also has, or claims it has, authority over the writing of the Constitution. And their legal reasoning, this should surprise judges in constitutional courts, is that they are allowed to strike down pieces of the Constitution based on our Declaration of Independence.
Thank you. Sorry to cut you. I will give the floor also to our Italian friends, but you will have to... Also, we compensated you in minutes for the hotel. You received 3 times more than okay, so it's very good. Thank you very much, Gadi, sincerely, and for your valuable insights. And we will, of course, continue during the panel, and please feel free to tell everything that you think. And Daniela, please, I give you the floor. If you prefer to go there or to stay here, you are free as you feel more comfortable. And do your introductory statement, please.
So thank you. Let me first of all very briefly introduce the way that Italy's legal system actually ensures the rule of law, because also it's important because we are in a process of significantly amending our constitution. We have a rigid constitution, so 4 rounds of votes are required by part of the parliament in order to amend it. If a 2/4 majority in the last 2 is not reached in both branches of the parliament, this reform could be actually challenged by a popular referendum. So far, our constitution has been amended several times, but always on marginal aspects. All major attempts of reform has failed. Giorgia Meloni is trying again now with this reform in order to provide for the direct election of the prime minister. Instead, the safeguarding of the Constitution is to the Constitutional Court, comprising of 15 members. 1/4 is nominated by the President of the Republic, 1/4 by the Parliament, 1/3 by magistrates. So our magistrates actually control 1/3 of the composition of the Constitutional Court. Moreover, the direct access to the court's jurisdiction is limited to judges during legal proceedings. There is no direct access for ordinary citizens, group of people, MPs. So judges are those, it's judges' responsibility to open the door for a constitutional review. Now, what happened is that about 20 years ago, the Constitutional Court, then presided over by Vittorio Nida, who would have later become an MP with the left, introduced a new principle. That principle is that a judge, an ordinary judge during a legal proceeding, shouldn't appeal to the court merely because a law could be interpreted in a way that is in contrast with the Constitution. He should do so only if the judge cannot find a way in which this law is consistent with the Constitution. This is the doctrine of the constitutionally compliant interpretation. Practically speaking, what the Constitutional Court did was to encourage ordinary judges to reinterpret the law whenever they find that this could be unconstitutional, and so apply their very personal interpretation of law. But since the judges are the only one who can appeal to for the constitutional review to the court, you can understand that this has created a very flawed system. So for 2 decades now, we have the ordinary judges, not constitutional judges, as the true interpreter of the constitutionality of our laws. And this has manifested itself stronger where there is a tension. Which is this tension? Is that between Italy's relatively conservative legislation and the large component of the magistrates that is progressive. So I'll give you a few examples of that. First one is regarding the self-defense law. So in Italy, self-defense is rightful when your response is proportionate to the threat. That, in principle, is quite reasonable. Problem was that many activist judges started to assess this proportionality not from the perspective of the victim, so an ordinary citizen that is, awakened in the night by an intruder, fearing for his life, the life of his family, incapable of assess the level of threat, and so on. They started to assess this proportionality with the perspective of some veteran elite soldier that should be able to perfectly assess the level of threat and exert the least necessary force in order to neutralize it. So if you defend in your house against an attacker shooting with a handgun and the attacker actually was armed with a knife, this wasn't proportional. You were convicted as a killer if you are lucky to find the wrong judge. So some years ago, the law was amended. It was had a new provision for which if you are defending your own house against an attacker threatening you, an intruder threatening you, you are doing so with a legally owned weapon, your self-defense is always legitimate. So what those activist judges actually did and are still doing in front of that, they ruled that in order to be constitutionally compliant, this provision, the response should be proportionate to the threat. So a law enacted by the parliament was nullified by ordinary judges. Second example is from the, clearly we have plenty of examples on migrant laws, but I want just to mention one. Last year, the Meloni government enacted a new law, a new restrictive law. Among the provision is that if you, as asylum seeker, have not the financial resources in order to sustain yourself, instead of wandering throughout Italy and trying to survive maybe by legal means, you must stay as a guest in state-financed centers. Now, an ordinary judge ruled that and set free some illegal migrants because she deemed this particular provision as unconstitutional. By the way, this judge used to attend far-left rallies against the government and in favor of illegal immigrants, so not very neutral. The third and last example is on gender-related issues. In this case, I can just mention and just quote what an important judge wrote recently on the main journal of the Left Association of Magistrates, referring to the problem of the recognition of parenthood to same-sex couples who acquired children abroad because through surrogacy. Surrogacy is banned in Italy. And this judge wrote that, quote, if the parliament doesn't act, the civil jurisdiction will take care of it. So no comment needed on that. I just spend a few words about this association of magistrates, which is called the Magistratura Democratica. In Italy, we have two parties within the judiciary because we have elections of within the judiciary for the Supreme Council of Magistrates, which is the self-governing body of judges and prosecutors. So, Magistratura Democratica was established in the 60s as the Communist Party of Magistrates. It's still radical left, very popular, extremely popular among our judges. And in its own words, so I'm mentioning the very written documents, they have been establishing in order to challenge the technical and neutral role of judges and to advocate for the external intervention of the judiciary alongside political and social forces promoting change, that, in my understanding, is just a euphemism for communism. So you can understand that clearly there is a huge problem with that, because the legislative power belongs to the parliament for obvious reason. The constitutional oversight belongs to constitutional court judges because they are mostly elected by the parliament or by the president of the republic, who is nominated by the parliament. Whereas ordinary judges are just public servants. They won an exam, they have never been democratically selected or elected. So their task is to simply apply the law, not to reinterpret it, not to selectively disregard the law. Rule of law means also, maybe mainly, the supremacy of law. This supremacy extends to judges as well. If the judiciary, if judges replace the parliament in making laws, they are undermining the democratic system. They are violating the principle of the separation of laws, which is a cornerstone of the rule of law. So if someone is going to ask you if the rule of law is under attack in Italy, you can answer yes, it's under attack, but not by part of the parliament, of the government, but by part of those activist judges, and it is since decades now.
Thank you very much, Daniele. And we ask an upload also for him. Thank you. So, what you said also, it's not only an attack on the rule of law, but also on the democracy, because the democratic power should be kind of under the rule of law. So the rule of law proponents are stronger, seems to be stronger, and seem to have the last word. And Gadi, you mentioned also something like this in Israel with the judiciary reform planned by the government. And this is also something, a debate which happened in Hungary. And in Hungary, what we had is that when there was the reform of the constitution, so the Hungarian constitutional assembly adopted the basic law. There was a question whether a part of the basic law can be annulled, cancelled by the constitutional court or not. So there was a debate who has the last word. And at the end, there was a kind of compromise solution, because they cancelled a part of preliminary, introductory, or preliminary. How to say? There was a part of not the preamble, but in annex, some rules which help the constitution to enter into force, and the constitutional court judged that these rules were not part of the constitution, so can they judge it? So it was a bit softer, I think, but we, of course, have a constitutional judge who is much more expert on this. But the question is, because in the Hungarian case, we had the constituent power against the constitutional court. So we had an extreme majority. So for the judiciary reform in Israel, what is the majority required? All the governments can do a judiciary reform, or it's an extraordinary majority required?
There is no rule. And this is what those objecting to the reform kept saying, that you need a larger majority. But the original judicial revolution, in which they established their power to strike down laws, was enacted in a half-empty parliament in a majority of 32 against 21. Nobody knew it was an important decision. So us supporting the reform said, we are just setting things back right after you snuck a stolen vote in the middle of the night to change the rules.
Thank you very much. And Daniele, you mentioned some cases, some more abstract cases, but we know as well that Italy has well-known politicians, not only the Prime Minister Meloni, but we talked a lot about former Prime Minister and late Prime Minister Berlusconi. There is also the Salvini case. Could you please give your views on the procedures that were led against them as well, please?
Yes, well, Berlusconi actually faced 30 trials during his lifetime, mostly, I think, all of them after he actually became a politician. The accusation ranged from corruption to child prostitution, from complicity in carnage, association with mafia, every kind of things. He was acquitted every time except one. In 2013, he was sentenced for the tax fraud. So, a minor accusations in the bunch of all the others. It is important to say also that 2/4 of these of the prosecutors in those trials were actually members of the aforementioned Magistratura Democratica. Well, even if Berlusconi almost always managed to be acquitted, those trials were very important and very, a big problem for him. Also because in Italy, usually a trial could last 10 or 12 years. So it's not easy to get out swiftly. There was a huge delegitimation for him, especially in the first trials, because the people haven't yet understand that this was a political tool. So, for example, his first investigation warrant for corruption was made public when he was presiding an international meeting, international conference on corruption. So it was very timely, this warrant. And the other problem is the expenses. Berlusconi could actually survive because he was very rich, but he claimed once that he actually spent only for lawyers something like 750 million euros. So not everyone could actually afford those level of expenses. As I said, 2/4 of the prosecutors from Magistratura Democratica. Now, about that, it's important to mention a book that was published in Italy 4 years ago. This book was from Luca Palamara. Luca Palamara used to be a very important judge in Italy. He was the youngest ever president of the National Association of Magistrates. He was a member of the Supreme Council of Magistrates. And he was the leader of one of the magistrates' party, namely the centrist one. So we have a center-right party, a centrist one, and the left-wing party. This centrist one was traditionally allied with Magistratura Democratica. Palamara was, even if he is leftist, he was leftist at least, at some point he decided to shift alliance and move towards the center-right party. It's very curious because he recalled in his book that after this shift, the very evening of this shift, one important prosecutor that also befriended him called him by phone and among a bit of chat just said him very casually, "Oh, you are under investigation, and we have also found out that you have an affair with Lawfare." So that was in this moment he actually understood that it was finished, and it was because he was indicted for corruption. He was expelled by the National Association. He was expelled by the judiciary. That's when he decided to publish this book. A tell-all book in which he detailed how this system, the system is the very title of the book, actually work in Italy. So all the collusion with parties in order to weaponize justice, especially the collusion with the Democratic Party, which is the leftist party, former Communist Party, now leftist party, main leftist party in Italy. And he's quite young, so he witnessed just the last part of the judiciary persecution against Berlusconi, but he can witness how this actually happened in close cooperation with politics. He mentioned, for example, the judicial advisor of then President of the Republic, Napolitano, who was from the Democratic Party, for example. So this is an important witnessing about how it actually works. About Matteo Salvini, Matteo Salvini, as Interior Minister 2018-2019, he managed to obtain a dramatically reducing in the number of illegal arrivals by sea. The year before he actually became Interior Minister, we had something like 120,000 illegal arrivals by sea. The year before it was 180,000. In 2018, so first year with Salvini as Interior Minister, the figure was 20,000. In 2019, it was 11,000, and almost a large part of that during the fall when Salvini was no more Interior Minister. So a tremendous success for his policy. Part of those policies are also the fact that when a ship that was transporting illegal migrants tried to enter an Italian harbor, he just denied the permission to access it. So activist judges reacted to that by launching investigations on those events with the accusing of kidnapping, is the formal accusation. Since he was still a senator, in order to put on trial a senator, you need the Senate authorization. The first request that was about the Gregoretti ship was denied because it was still in the majority. The second and the fourth, the first was the Ciotti ship. The second and the third are Gregoretti ship and open arms ship. This authorization was granted by the Senate with the decisive vote of the Five Stars movement that used to be allied with Salvini, and they voted against the trial in the first case. They changed their mind suddenly, and they decided to send him on trial. Well, about Salvini also, we can say, I get back to Mr. Palamara. There is a wiretapping of Palamara when he was still a member of the Supreme Council of Magistrates, and we know that they were coordinating this judicial attack against Salvini. In this wiretapping, a friend of him, another prosecutor, actually was texting him, texted to Palamara, well, I'm a leftist, but, actually, you cannot find any wrongdoing in what Salvini is doing. There are some people who are trying to enter illegally our country. He's the Interior Minister, so he's just trying to avoid that this crime happened. And Palamara replied, yes, I know, you're correct, but we must attack Salvini. So that's the spirit of a large part, unfortunately, of our judiciary.
Thank you very much. And Gadi, you mentioned, and you quite well elaborated on the question of the tension between the judiciary power and the government in Israel. And it was especially before the war. Now that the context changed and obviously the war became the number one issue, is it still a question in the public opinion, this judiciary reform, the past tensions, or are the general citizen aware of these tensions? How does it look like inside Israel now?
It's not just an important, but also a very complicated question, because what we saw in defeating the reform was an alliance with the army, and the army, there were a lot of reservists. They were threatening not to come to their service if the reform passes. Now, the same elite in the army and in the judiciary operated together to block the reform. But then the war came, and people are blaming the army for the refusals which brought the war. So the judiciary is not exactly hurt, but their alliance with the army is, I think, completely broken. And in the minds of the people, this is the same elite. So the way I see it, in the formal battle, we have completely lost, because now that they say that they can strike down our constitution based on a declaration of independence, which we cannot change. So they have now an authority to interpret a very vague document and do whatever they want. So they established complete authority. They now formally hold sovereignty. We are not a democracy. But informally, this elite, in my opinion, is on its way out, because this is a massive failure and it's associated with the struggle against the reform. So now you see on Twitter, you see people again and again posting the videos of all these, what they call themselves brothers in arms, all the people who said they will refuse to report to army duty, and people saying we will not forget. So it's not directly related, but in my opinion, it's the end of this elite. And so it is on its way out.
And what is the reaction in Israel to these warrant arrest issues against Israeli leadership, for example, by the ICC and also the ICJ judgments? Could you please elaborate a bit on this?
Yes. People see it as a transparent political move by a kangaroo court. That goes without saying, but it also strengthens Benjamin Netanyahu's hold on power. Because, and it's funny because I've been commenting on this in my podcasts endlessly. The Americans are trying to orchestrate the ousting of Netanyahu. They are explicit about it. They're also arranging the protest. And the protest people are confessing it because they are showing off. We are coordinating with the White House, they say. And so whenever this happens, the other candidate, which is Benny Gantz, is forced to hug Netanyahu because Netanyahu now represents the Israeli interest. So if you support Haag against Netanyahu, you're doomed politically. So in this whole constellation, what is happening is that it strengthens Netanyahu, and Netanyahu does, I think, the exact right thing by just sticking to one issue. We should win this war. And this is what Israelis feel. So the elites, mind you, are increasingly against the war. And since they are being blamed for the war, this is only part of their thinking. Now, it may be that a certain constellation will deliver Benny Gantz the premiership, especially if he pretends to be a hawk and then creates a left-wing coalition. But this is short-lived because Israel is moving vastly to the right, and it has been reminded where we live, in what neighborhood, and what can happen to us. And so the return of Holocaust-style horrors is going to be a major shift in the Israeli psyche. And what I hope will happen is that eventually other countries, especially the West, Europe, and the United States, will wake up to the fact that there is a war between civilization and barbarism, and only Israel is fighting it. There is a war with Iran, which is going to be a nuclear power. It's a danger to everyone, and only we are fighting it. So I think the whole issue is going to be like rearranging the furniture on the Titanic after it already sunk.
Thank you. Thank you very much. Daniele, you obviously, in Italy, there was a change in the leadership some years ago. And before your elections, before Giorgia Meloni came to power, I think the day before or 2 days before, the president of the European Commission at the University in the United States of America answered the question, what happens if things go wrong, to quote her. She said they had the means in the European Commission, which was interpreted like a political blackmailing prior to the elections on the electorate, so on the voters, and then later on, of course, on the government. So how do you see this question? Did this have an impact on the government, on the future, and now the current government? And how do you see the margin of maneuver of the government of Giorgia Meloni after the June's election?
Well, when von der Leyen actually made this declaration, Giorgia Meloni didn't react. Salvini did, but not Giorgia Meloni. We have understand why. It's in less than 2 years, everything has changed because now von der Leyen and Meloni are very close. They pose as best in many situations and photo opportunities. Meloni would like to support her as the next president and president of the next European Commission with a new majority. Von der Leyen has somewhat defended Meloni in the debate of the Spitzenkandidat, and so much has changed. I think this is because of a precise strategy by Giorgia Meloni, that is to take on one enemy at a time. There is a politician that critics of Giorgia Meloni actually says is somewhat his precursor, that is Benito Mussolini. Benito Mussolini used to say so much honor, so much enemies, so much honor. That's not the same mood of Giorgia Meloni. She is quite on the opposite. She wants to have the less enemies as possible. She is now focused on the internal front with this constitutional amendment for the direct election of the prime minister. She's changing the management of the state-owned media, not just changing the management. There are important maneuvers because so far the journalists of the state-owned media were controlled by a unique leftist labor union. This labor union actually mediated for the job contract of all the journalists of the state-owned media. And so they usually also provide to insert in this contract some ideological provisions, such as the respect for the so-called Rome Chart. The Rome Chart is a document devised by far-left journalists in order to control the speech. For example, if you are describing illegal migrants, you cannot call them illegals. You should call them asylum seekers. And this is part of the work contract of all our journalists in state-owned media. If you do not respect it, you can be sanctioned by the public broadcaster. You can be sanctioned, obviously, by the order of journalists. All our journalists should be in that order. It is remnants of all the fascist laws. She's also pursuing a reform of the judiciary. A first small step in this reform. It is the same flagship proposal that used to be of Berlusconi. Now Berlusconi is dead. We are still struggle to have at least this approved. That is the separation of careers. Nowadays, judges and prosecutors in Italy are colleagues. They pass the same exam. They stay in the same order. They can move from one career to another. Until some years ago, they can move 4 times during their career, so they can be judge, then switch to prosecutor, get back to be judge, and then again to be prosecutors. Now, there is only one switch, but the intention of the government is to eliminate at all this possibility, because it's quite strange that in a trial you have a judge and the prosecutor that are actually colleagues, and maybe the judge that used to be a prosecutor and the prosecutor that used to be a judge.
Isn't this goal challenged by the European Court of Justice, for example?
Not yet.
Not yet. But now you said it, so maybe if they watch the video. Okay, so thank you. Gadi, you mentioned you have a podcast, so you meet a lot of international people, and obviously you have a broader knowledge of what is happening globally in the question of the rule of law and the tension between democracy and the judiciary power. So would you want to share some thoughts on this global picture or comment on the Italian cases?
Just to say that it was... I first wrote a book about Israel, and then I realized how pervasive the problem is, because our problem is so far exacerbated that we didn't notice the other example. And so I read you, I read John Fonte, who I think is first of all, the most important political thinker of the beginning of the 21st century, but he realized that it's a political struggle between transnational progressivism and democratic sovereignty. And so I'm just grateful for such conferences, because I think sharing our experiences will help us learn from each other and also to join forces.
Thank you very much. So you would support the initiative I mentioned to work closely together?
Let me think about it, but I think I will.
Thank you very much. I don't know if you have any comments to make, or we are coming close to the end of the panel. So if no, I think that we can conclude and thank the audience, because it was a huge session. And I think that this is the coffee break, but the organizers will obviously announce it. Thank you very much.
First, that law should dominate any discourse on the rule of law instead of politics, although these days we see a gradually more slippery slope slanted towards the arena of politics in this sense. And the second is that we should never neglect the state-bound origins and evolution of the concept. We could also say that the national level is the natural habitat of the concept as it was originally conceived. Obviously, there's need for standardization on the international level, and we do have the Venice Commission, for example, of the Council of Europe, which in its name is a commission for democracy through law. So there is a legal standpoint. And when it looked at the rule of law first, maybe 12 years ago, it compiled a report that had a few important findings that I want to share with you before we start our discussion. The first thing was that rule of law isn't really one thing, it's more things. Rechtsstaat, état de droit, rule of law, these all refer through different expressions to the different context origins of the concept. And the Commission also says these should be reconciled with each other. And in this effort of reconciliation, the Commission attempted to put together a checklist, a rule of law checklist that all member states of the Council of Europe should feel as mandatory on them. It had soft law, hard law approaches, it had benchmarks, general standards, just for ease of reference, legality, for example, legal certainty, prevention of abuse of powers, non-discrimination, or access to justice were elements of this list. But the report also very importantly stated or asserted that it is questionable whether the rule of law should be used as a fundamental concept of public law. And it said so especially in the context of post-Soviet states. However, it also declared that it is a very important primary feature of states. And if I want to turn here for a moment to the EU, and if I operate under the assertion that statehood or the state level is the natural habitat of rule of law, then obviously we can start from the determination that the statehood of the EU is questionable. So this brings about the question whether the EU has power to define and enforce what rule of law means. There's many approaches that we can apply in the external aspect of the rule of law, is what Reinhard, the German political thinker, calls this. He says that the EU institutions should act within the remit of their powers that have been given to them through conferral of competences by the member states. And this back and forth or balancing exercise between the member states' constitutional courts and the Court of Justice of the EU is really a pendulum that swings back and forth between trying to decide about open or closed statehood. And by this he means defining the relationship of the member state toward the integration and the extent of the transfer of competencies that comes with it. Arnold also says that the integration process itself should run or should rest on a rule of law basis. The EU, obviously, as we've all seen, has since then created a mechanism that then turned into a reporting on rule of law that is directed not at the EU level, but on the domestic level, also many times focusing on domestic justice systems. It does not define rule of law. It says it's a common value. Other points, it says that it's an established principle that has a common content all across the EU. However, it has created mechanisms that form our common understanding about the rule of law through a political dialogue. And my colleague, Rodrigo Ballester, who's a ministerial commissioner for the internationalization of education and also head of European studies at MCC, is going to talk about exactly this, how the EU uses its competence or lack of competence to pass judgment over member states, very often in the context of their domestic justice systems, under the guise of rule of law concerns that are raised in a political rather than a legal context. And I think this will organically build upon some of the things that we have heard in the previous panel. However, and I do, if we accept that rule of law is a fundamental concept of public law, then legal approaches should dominate this deepening of understanding, as it was phrased by the EU. And we do have a saying in Hungary, ahány ház, annyi szokás. As many houses, as many customs. So I don't think that we could neglect the sui generis legal contexts of the national development of the rule of law concept when we talk about this in Europe. And in this approach, Supreme Court Justice Alexander Stepkovsky will first address a broader intellectual context of the rule of law concept, pointing to its ambivalent nature, trying in this way to explain our current confusion about what the concept really means. Then he will illustrate against this background how the Polish Constitutional Court had approached the concept over time and how it had developed in constitutional case law, at times manifesting conservative and also progressive understandings of the concept. I guess there is a point that I'm trying to make. If we are looking at this deepening understanding of the concept as a race, it devalues what we're trying to do. The rule of law, or understanding the rule of law, is not like the space race. It doesn't have winners or losers. Every state simultaneously is a winner and a loser on the different front lines of the rule of law. Some of the things that this involves, some of the battles that we're fighting are acute. Some symptoms that we're trying to tackle are obviously chronic. And I think it's very hard to credibly create such indexes or scoreboards or lists of conditionality, whatever, where each and every state can be judged independently according to the same abstract levels of success or failure in this sense. And whenever we're trying to do this, it diminishes the role of law. It emphasizes financial considerations, economics, politics. So there's this mindset that comes with this. This is omnipresent. I'm just saying that we should maybe focus more on the legal side of the concept. However, national jurisdiction, including domestic justice systems, can be assessed through legal means or through more legalistic lenses as well at the international level. And this is where I want to briefly refer to the European Court of Human Rights, because for about maybe 5 years now, there has been a string of case law that dealt with domestic justice systems under certain rule of law considerations. The first decision to do so was an Icelandic case, Gudmundur Astratsson versus Iceland, I think the name goes. It was in December 2020, and it looked at the principle of a court established by law. And it had said, for example, and I quote, in the context of judicial appointments, technical competence and moral integrity to perform the judicial functions required of it in a state governed by the rule of law is paramount. This case was a precursor of a huge Icelandic judicial reform, and it looked at this requirement that I mentioned in a rule of law context. I will not talk about the case anymore because I'm abusing my power as moderator as is. But the string of this case law delves more into the Polish aspects, and I will maybe leave it to Justice Stepkovsky to speak about this if he wishes so. I merely meant to point out that there are certain international organizations that rightfully take it upon themselves within their mandate to assess domestic justice systems through the cases that make it to them, but they will obviously take into consideration national approaches to the rule of law as well. And to finish, really, this time, I want to mention a recent contribution to the rule of law debate by Professor Ellen Brewer-Carrillas. It was published late 2023, mostly in the context of Venezuela and Latin America, but containing very important notes on what he calls the new or fake rule of law. And he conceptualizes this new fake rule of law, and I quote, as a degradation of the essential minimum principles of rule of law that every rule of law state must have. He also points out that these are systematically being reached in Venezuela, but I think that we should enumerate some of these to make my final point. The first is constitutionalism, the second is separation of powers, with a heavy emphasis on how the judiciary interacts in this legality, humanization, that refers to the recognition of the existence of natural rights with a constitutional rank, and the role of the judiciary protecting this, political decentralization, and the principle of civil government. And if we look at this list, I teach the rule of law to my students at university every semester, and they won't find such a list in European or Hungarian constitutional law textbooks. So obviously, this list that Brewer Korea has put together might be indicative of a regional Latin American rule of law culture. So to me, it teaches, and I hope it teaches all of us, that we should not look away from different national contexts, and we should have a common understanding, to use this Shakespearean term, about what is in a name. And if we look at the internal aspect, obviously, we have to look at the core elements of how the concept had evolved. And if we look at the external aspect, then obviously we have to define those rules of the game that international organizations have to respect themselves in terms of what the domestic justice systems are allowed in shaping and upholding the rule of law on the level of the state. If we don't do this, and if we cannot agree that we are allowed to have diverging approaches on what the rule of law means, then if you allow me this dead joke, instead of justice, there will be just ice between the partners on the playing field, and the conflicts will be frozen. And right now, to melt the ice and to bring about some much-needed climate change, I will first give the floor to Professor Stepkowski. Thank you.
Thank you very much. I will use the standing mode in order to be more motivated. Forgive me very much. I would like to ask you for forgiveness. I would like to start with conscientious objection. I have heard here during the conference many things to justify the conduct of Israeli army and Netanyahu government, and I have to object in this respect. Having said so, I am not going to continue in this respect, but I want to be a man of conscience, and I had to make this statement. So when we are speaking about the rule of law, we have to ask, and especially here, in order to understand the confusion, our confusion about the concept of the rule of law, whether it is protective concept, which is protecting certain social order, or it is a lawfare. We have to start with understanding what law is supposed to rule. And here we have to understand that what we are speaking about is the modernized form of the rule of law principle. So we are not talking about the pre-modern common law concept of the medieval concept of the rule of law, but only about the modern concept of the rule of law. And here we face the internal disagreement within the way of understanding the law, which modernity brings to our world. Modernity is just founded upon the rejection of the principle of self-identity, and therefore it is promoting some concepts which are self-conflicting, and the law, and it applies to law also, because on the one hand, modernity brings us the principle, the idea of natural law, which is to be implemented, ethical ideal of natural law, which is to be implemented by statutory means as a text, as a legal text. And this makes the fundamental disagreement whether we are promoting some ethical agenda or we are promoting just the exegesis of legal text. Yes, whether we are naturalists or positivists, yes, but it is inherent in the very modern idea of the law. And as we are facing this inherent disagreement within this concept, the concept of the rule of law is also portraying this twofold reality of the law. So the idea of the rule of law is portraying this idea of modern society within the modern state, and also is showing us certain ideal to be implemented. So it started with the implementation of natural law agenda, natural law principles, which were equality and freedom. It is the basic understanding of individualistic anthropology upon which modernity is founded. But this natural law concept was first of all directed toward the decomposition and abolishment of the old society, old feudal society based on communities' life, and to create new social order based on individuals. And once it took the place during the revolutionary process in 18th and 19th century, it just implemented this anthropological agenda, this individualistic anthropological agenda into the statutory instruments. First of all, within the civil codes of 19th century, based on the principle of autonomy of will, so the freedom, and the principle of formal equality of subjects, so the principle of equality. Yes, and therefore the civil codification, civil codes were so crucial in the 19th century for the creation, establishment of national states. Yes, it is the core idea in the 19th century. And once the modern national state, modern sovereign national state was created according to this agenda, it was implementing this anthropological agenda to make people more free and more equal, and to grant them with some prosperous life. And the modern state was the primary tool to implement this political agenda. But the modern state, after some time of implementing this process, first by means of statutory law, and then by application this by the within the courts, once they exhausted its potential to promote this anthropological agenda, it started to build some supranational structures, European communities, then transformed into the European Union, in order to promote the same goal. But this superstructure was no longer modern, it was postmodern. And we are living today in postmodern times. And this task of implementing social order based on freedom and equality, still expounding freedom and equality, now is first of all implemented from the level of European Union. And the national states, which are enough modernized, they incline to this agenda and cause no problems to this advancement in the implementation of individualistic anthropology, whereas some under-modernized countries are not mature enough, not democratic enough to understand the goal of civilized societies, and they started to oppose. And this is the case of Hungary and Poland. So this process of building supranational, so postmodern statehood within the Europe is consisting on gradual decomposition of national states, which are modern structures, and which start to oppose to postmodern structures. Yes, and going into the national, on the national level, for a long time, this superstructure was very useful in promoting this individualistic agenda, so to make people more free and more equal. But at some point, people started to oppose to gender ideology, LGBT agenda, and so on. And these are individualistic agendas, where people are supposed to be liberated from their sexual identity, and to purify them to be clear individual, not polluted with some sexual identity. Yes, and when those countries started to oppose, the confusion appeared. Yes, so this confusion appears first of all on parliamentary ground, because parliamentarians are dependent on their voters and etc. But for a long time, constitutional courts were directed toward somehow implementing, forcing this European agenda despite the opposition from the parliament. But in Hungary and Poland, also judiciary changed. And this made the crucial problem for this postmodern agenda to be implemented, that neither parliaments nor the judiciaries wanted to implement this. And this is what we are facing today. And here is why the rule of law stopped to be the principle of order, the principle of rules, of observing rules, etc., and become the lawfare. Yes, to impose by force certain political agenda. And now we can land in Poland on national level. And as you very know very well, communists collapsed in Poland. Well, we believe it ended in 1989, in December, with the implementation of the constitutional change, which changed also which abolished certain provisions of communist constitution, and certain and other provisions were upheld, and some were changed. And the crucial provision in this respect, which was changed, it was the Article 1 of the former communist constitution, which was defining the Polish state no longer as a People's Republic of Poland, devoted to implement socialism, etc., but as a state democratic state under the rule of law, implementing social principles of the social justice. And the Constitutional Tribunal, which was created during the communist time in 1986, much could be said about who was standing behind the implementation of the first crucial institution for liberal democracies in Poland. It started long before 1989. During the time the communist secret service was at most developed. There were over 100,000 functionaries of the communist secret service, but I am not going to discuss this further. So the Constitutional Tribunal, after this constitutional change in the December 1989, for 7 years was elaborating certain constitutional principles upon this principle of the rule of law, democratic state ruled by the law. So it took very activistic approach to constitutional case law, but it was considered as something very positive because it allowed the transition from communist time to liberal democracy. So it was in majority applauded and very well received, even though many lawyers were protesting that they are just legislating as judges. How it is possible under the division of power? But it was accepted. So as long as it is accepted, judges could legislate in this way. But in 1997, new constitution was adopted by the parliament in majority composed of post-communist parliamentarians. And then Constitutional Tribunal decided that it is no longer going to to be very activistic upon this principle of the democratic state based on the rule of law and implementing social justice policies, which was also included into the new constitution, because those principles which were declared upon this article were already implemented into the constitution. So now we need only to apply those constitutional provisions. So we moved from naturalistic approach to positivistic approach. And for a long time, especially, and now the issue of European integration comes. And Polish Constitutional Tribunal, regarding the issue of European integration, took complex position, but I think not an exceptional one. It was in fact promoting European integration, whereas rhetorically was very strong about supporting national sovereignty and the primacy of Polish constitution. When it was confronted with certain issues which were in an objective way not reconcilable with the Polish constitution, then it tried to avoid somehow problem. Once it even declared the unconstitutionality of the regulation, European Union regulation on the ENA, so European arrest warrant, because Polish constitution does not allow to extradite Polish citizens. And Constitutional Tribunal said that in case of the clear contradiction, first, of course, Constitutional Tribunal and all the constitutional organs must interpret Polish law in such a way to conform with European law. But once there is clear opposition, and you cannot reconciliate this by means of some intensive interpretation, then Polish constitution must prevail. But Polish constitution declares in Article 9 that Poland is bound by the international law which was accepted, so it was ratified. And if we reject to observe the European Union law, then we contradict this Article 9. So we've got contradiction. So favorite situation in the modernity and postmodernity, contradiction. And because of that, Constitutional Tribunal declared that there are three solutions. First, we can leave European Union. Second one is we can start the procedure to change the European Union law. Not very realistic. And the third, to change the Polish constitution. And they declared unconstitutionality. They postponed the entering into the force of this judgment for 18 months, saying that Polish parliament must amend Polish constitution, and there will be no clash. So that was practical dimension of this judgment. Even though, from the rhetorical point of view, it was very strong message that yes, we can rule the European Union as non-conformant to the Polish constitution. And we did it. But then we required the parliament to change the constitution. And this policy of loud barking and not biting was very typical for Polish Constitutional Tribunal, and not only for Polish Constitutional Tribunal, actually for all the constitutional tribunals within the European Union. And within the stages of the European integration, we've got, for Poland in 2004, we have the Accession Act, to the Polish to the European Union, and then we've got ratification of Lisbon Treaty. And on both of those occasions, Constitutional Tribunal was ruling about the conformity of accession treaty and then of Lisbon Treaty with the Polish Constitution. It could see no problems in respect of the conformity, but it used this opportunity to declare very strongly the protection of Polish constitutional identity within the process of European integration, admitting that European integration it's not it's not a stable situation, but it is a process. Yes, so we are now accepting rules which we don't know what shape will take in a few years. And Constitutional Tribunal emphasized that it is of crucial issue not to allow to infringe constitutional identity of Polish constitution within this process. Yes, it was based on the interpretation of Article 90 of the Polish Constitution, which predicted the accession to the European Union and declared that Polish Parliament can transmit certain competences of Polish constitutional bodies to the international organization. Certain. Not all. And upon this, it was declared that there are some competences which could not be transmitted. One of those competences, it was the creation of Polish and organization of Polish judicial system. And after 2016, after 2015, when the political change took place, the then governing party, after some political experience from the earlier process, they decided to start the reforms with the reform of judiciary, which was complained very much, also from within the judiciary. Yes, it started with Constitutional Tribunal, you know the story more or less, and then it started with the Supreme Court. There was no enough political intent or determination or any way to go into the common courts. And this situation was addressed by international organizations, so the Council of Europe and the Strasbourg Court and the European Union, of course. And here we can see perfect orchestration between two structures and two courts in doing their policy. I would like to, in order to demonstrate some feature of this rule of lawfare in the Strasbourg context, which the Strasbourg court was breaking the path for questioning the judicial reform in Poland, and it started with Astrason case, so not related to Poland, and very different from Polish case because their rules of the judicial appointment were manifestly broken, whereas it was not the case in Poland. And they started with the opinion of the Venice Commission. What is interesting about this opinion of the Venice Commission from 2017, that Venice Commission started to work on its opinion upon the draft law, which was very much different from the law adopted. The draft law appeared in September 2017, and the law was adopted on 8th December 2017. And the opinion of the Venice Commission was adopted after the adoption of the statute on Supreme Court, new statute on the new law on the Supreme Court, Polish Supreme Court. But the content of the opinion related to the draft from the September, which was very different. And it was strongly criticized upon the issues which were changed in the draft law and never become the binding law. But after the adoption of this outdated opinion of the Venice Commission, this outdated opinion of the Venice Commission, just for your notice, the opinion was prepared by the Russian employee of the Venice Commission, which developed the analogies between the Polish Act and the Communist Bolshevik revolutionary acts from 1917. So it was huge abuse, having nothing to do with reality. But you know, Russians' approach to Poles is specific and well known, and it was efficient in this respect. So this opinion, which contained some statements contradicting the existing legal provisions, it was taken to the Parliamentary Assembly, and it was repeated with those false statements concerning the primary draft, not the actual statutory text. And then it was repeated in the Strasbourg court. Strasbourg court does not pay any attention to the statutory regulation which it is criticizing, but to the opinion of the Venice Commission, which was not on the statute but on the draft. And who cares? Venice Commission declared, Strasbourg declared, Luxembourg followed what Strasbourg declared, and you've got rule of law. Of course, there is one more condition which is necessary in this respect, and here Hungary is very different from Poland. Just Hungary is much more unified, and there is not so many people who prefer to support cause of the European Union and the Council of Europe against its own government, unlikely in Poland. Unlikely in Poland, the vast number of judges and vast number of politicians and intellectual elite, etc., is supporting European Union against its government. And it is just finishing. It is also very important to understand one thing, that Polish judiciary was transmitted from the communist time to the new liberal democracy time without any change. People who were sent to the Supreme Court from the military secret service, communist military secret service, they were serving as judges, and then they became the presidents of the Supreme Court, and such a person just retired in March this year. And he was the key figure of the symbol of defending the independence of Supreme Court and Supreme Court judges, etc., fighting for the rule of law, etc. So this is very, very important, aspect which should be also taken into account. Thank you very much.
Thank you. Thank you, Professor, for polishing our understanding of the Polish situation in terms of rule of law. And now we're stepping one level up, or down, well, depending on where we look at it. Rodrigo, please, you take the floor.
I prefer to use this microphone. Thank you very much. It's working. Jó napot kívánok. Thanks again for your hospitality to the Danube Institute, Alap Jogokért, European Conservative. I'm honored to be here with you. Some words of caution as well from me on something else is the notion of lawfare. It is also used, for example, in Spain by the extreme left and the extreme independentists to question not like the excess of the judges, but the simple separation of powers. And so we have to be somehow prudent as well with this notion because, again, it can also be manipulated in another manner. Otherwise, when it comes to the rule of law, on the rule of law fair, it was just said before, allow me to be less nuanced, especially when I speak about the European Union. I am very skeptical about the possibility of the European Union to even play a positive role in the field of the EU, of the rule of law. Why? In one word, because it's not competent. And by competent, I mean three things. I mean, first of all, that no one gave the EU a clear mandate on that. By competent, I mean that they don't have the skills, nor the wisdom, nor the tools to do it properly. And third, because by experience, and we can also look at the last 5 years, they just politicize it. And to politicize the rule of law, it's a legal sin. It's a legal sin that shouldn't be allowed, and for which you lose all your credibility. And this is exactly what happened. In the last 5 years, the mandate of Mrs. von der Leyen has been characterized by the war, by the COVID, but also look at that by the rule of law, by type of rule of law activism that has been, used in conjunction with the budget under the terms of conditionality to basically try to put some countries on their knees. And by some countries, I mean, surprise, surprise, Hungary and Poland until a couple of weeks ago, because suddenly they return into the best graces of the European Union without a very thorough legal assessment. So again, there we can also ask some questions about it. I just wanted to illustrate my point with 3 examples. Again, that the EU is not competent, and also to add something else is that we just get used to give the competence to the European Union of the rule of law, so we consider them now like the official watchdog, the official Rottweiler, the guardian of the rule of law. But actually, if you look at the guardian, do they live by their own standards? Do we know if there is a problem of the rule of law in the European Union? The first thing I learned about the European Union when I was a first-year law student 25 years ago was something called democratic deficit. A large notion, but it's also related to the rule of law. So are we also given now the competences, maybe to the entity that respects them the less? What if the policeman is the most criminal in the crowd? 3 examples for that. Again, the notion of the mandate. Second, let's speak a bit about the European Court of Justice. And third, I think there is now a very important example that is really illustrating how the rule of law can be turned into a mockery, into a caricature, and into arbitrariness, which is the case of the exclusion of the Hungarian universities from Erasmus and from Horizon. So apart from being a politically stupidity, a moral infamy, from a pure legal point of view, and I will only dwell on the pure legal point of view, it's nothing short of arbitrariness. Let's speak about the key word of my intervention, competence, competence, and competence. There is an Article 5 in the Treaty of the European Union, one that I think is really beautifully drafted, and because it's very clear and straightforward, and me as a lawyer, I like clear things, I don't like gray zones. And this one says, I'm going to quote it, under the principle of conferral, the Union shall act only within the limits of the competences conferred upon it by the member states. Competences not conferred upon the Union in the treaties remain within the member states. This is the most poetic part of it, so I'm going to repeat it. Competences not conferred upon the Union in the treaties remain within the member states. So for me, this is like the key article of the whole the Treaty of the European Union. This is really like the golden rule. It's like saying that football is played with the feet and handball is played with the hand. But somehow I have the impression that it became more like an incantatory principle, like a Ming jar that you keep somewhere in a museum, that everyone looks at it, but no one really respects. No, this is not to be something, an antique. This is something, it's supposed to be the golden rule. Does the EU live by its own rules? The answer is absolutely not. I'm not just going to give you, within this point, 3 little examples as well. Again, is the EU basically going ultra vires, basically clearly beyond its competences? My first example is the rule of law, obviously. The rule of law basically applies to everything. Suddenly it becomes a catch-all decision. It gives a general competence to the European Union on absolutely everything. Because you just need to invoke the rule of law, and that's it. You have a general competence. Well, I expect a much more solid legal reasoning to take that. A very concrete example, and this is also something that relates to what Justice Stepskowski just said. All the fights, the struggles, the confrontation between the European Union and the Polish government, but also the judiciary, as you said, in the last 7 years, regarding the organization of the Polish judiciary, relies on this sentence in the treaty. So because we can ask ourselves, does the EU have a clear competence? Did the member states agree that the judicial organization at national level should suddenly become an EU competence? No. The only legal base they use is the following one. It's basically 15 words. Member states should provide remedies sufficient to ensure effective legal protection in the fields covered by the union law. This sentence, this one sentence, justified all the crusade that the Commission and the European Union in general, it's not only the Commission, launched against the government of Poland. Again, let's think a bit together. Do you think that it's enough when your mandate says member states shall provide remedies sufficient to ensure effective legal protection in the fields covered by union law? Do you read something like the EU is now competent to tell member states how they have to organize the judiciary? I mean, from a purely cognitive point of view, the answer is obviously not. I give you another example, a very recent one. A couple of weeks ago, the EU finally adopted the EU Media Freedom Act. EU Media Freedom Act, which is very intrusive. Actually, it covers, for example, the funding of public broadcast. Also, it defines the role of the journalist and the editor. It limits actually the role of the editor. Fine or not, I don't know. That's not my question. As a lawyer, I'm asking, does the EU have a mandate on such an important topic? You know what was the legal base? Article 114 of the Treaty of the Functioning of the European Union, which is basically meant to serve the establishment and functioning of the internal market. So, for example, to approximate the legislation of dishwashers, palinkas, technical standards, and suddenly they use it just to create out of the blue competence on media freedom. Well, if media freedom is related to the internal market, then tell me what is not related to the internal market. And then, you know what, I suggest something for the future of Europe. We can rule the whole European Union on one article only. This one, that's it. One article, and that's all we need. So, is that like going beyond its competences, or is actually even going beyond, legislating beyond its competences? Third example I wanted also to give you. One of the reasons why today Hungary is deprived of billions of euros, one of the reasons, this is very clearly stated by the European Commission in their press releases, is the Hungarian law on the protection of minors, which basically says no to the sexualization of minors, no to the entrance of, to the, like the access of NGOs, sexual minorities NGOs for minors, no promotion of homosexuality and of gender agenda, the gender theory. Again, as a lawyer, my question here is not whether I like or I dislike this law. Just a little footnote, I like it very much. But the question here is not whether it's good or not. The question is whether the sexual education of Hungarian kids should be decided in Brussels. Do I have a clear mandate? No, they don't have a clear mandate. To the opposite, the treaty says clearly that Article 165 of the treaty says that the organization and the content of education relies exclusively on the member states. The Charter of Fundamental Rights, this wonderful Charter of Fundamental Rights, which is basically cherry-picked in every legal case of the Commission against Hungary, says also in Article 14, paragraph 3, that the right of the parents to educate according to their beliefs. Never quoted this one. So again, where is the competence to suddenly decide that because you adopt a legislation on the sexual education of children, you don't get billions, European billions for that? I'm missing like 10 steps of legal reasoning there. So when it comes to the competences, I think we can agree that indeed if there is a huge problem here in the European Union, is that it systematically and blithely and happily goes beyond its competences. Second point I wanted to show you as well is the ECJ, the European Court of Justice. the Court of Justice that is telling the Polish judiciary or the Hungarian judiciary how basically they have to play and what is allowed and what is not. So basically the watchdog. Good, fine. But you know that all courts in Europe, absolutely all of them, are submitted to the European Court of Human Rights, except one. Except only one. Which one is it? The European Court of Justice. Oh, bizarre. I'm a bit surprised because in Article 6, paragraph 2 of the treaty, it says that the Union shall accede to the ECHR, the European Convention of Human Rights. Such accession shall not affect the Union's competences as defined in the treaties. Again, a very clear treaty. So there is a mandate of the treaties that, please, EU, you have to be part of this convention like everyone else. Actually, the EU negotiated with Strasbourg, with the Council of Europe, and they managed to have an agreement, I think, in 2011. Except that everything was blocked in 2014 by an opinion of the European Court of Justice saying that, oh, no, sorry, we are different, we are not worth it, so we just blocked it. So basically today, the European Union is not part of this convention because its own court refused it despite a clear mandate of the treaty. Rule of law. Do we call it rule of law? Do they have a credibility to teach lessons to the Polish judges after that? I'm not so sure. What I dislike as well about the European Court of Justice is that I find it extremely lonely as well. And I'm not pitying them, to the opposite. I think, you know, when I look at the member states, I like the fact that you have 2, if not 3, kind of supreme courts or superior courts that are somehow balancing each other. You have a constitutional court, you have a supreme court, sometimes you have a Conseil d'État, an administrative court, for example. And in the European Union, you only have one that is not even supervised from above by the European Court of Human Rights. They decide on everything, on absolutely everything, without a single judicial counterpower. Loneliness in this case becomes very, very dangerous. And then another example as well. What is the whole battle about the judiciary about? Is that the European Union doesn't like that parliaments are somehow nominating the judges. They want them to be totally separated. They want the judges to nominate the judges. Personally, I don't share this point of view, but I must say it's defendable and it's something to be discussed. But wait a minute. How are the European judges nominated? By their own governments, which is fine for me. It's fine for me. But again, look at yourself, dear European Union. So Brussels, Luxembourg, Strasbourg, please look at yourself before you start teaching lessons and basically depriving countries, trying to thirst them financially, when actually you couldn't leave, you will be the last to represent your own standards. Third example that I wanted to give you is precisely this Erasmus and Horizon case. Again, let's forget the political and the moral dimension of it, which is extremely important, legally speaking. This is linked to the conditionality of the rule of law, which is now like the cherry on the cake. You don't only have like fake competences on the rule of law, but now those fake competences, you can tie them to harsh financial sanctions that can be basically adopted ex ante for totally hypothetical, if not imaginary, behaviors. What is going on here? The European Commission doesn't like the way 21 Hungarian universities are managed. Those universities have one senate and also a board of trustees. And they say that, those board of trustees do not respect academic freedom. Again, first legal argument, do you have a competence for that? No, but it's the rule of law. And so, the rule of law is like the joker. You can basically justify any competence on that. And then they just claim that, the way those board of trustees are composed might one day have, peut-être, possibly, arguably, have an impact on the EU budget. And so in order to protect the EU budget, I kick 180,000 students out from Erasmus and Horizon. Well, imagine that suddenly, I just have the impression that Martin, for example, I really have the impression that he's about to steal my watch. And so on this presumption, I just call the police and basically they take him to the police station. So the fact, as a lawyer, that you can be sentenced, you can be sanctioned on a purely imaginary behavior. You can be excluded, imagine, from a championship, from a football championship on the first day of the championship, just because I assuming that in 3 months, maybe one of your players is going to commit a bad fault that is going to result on a red card. Let's kick out the team. Are we really applying that in the name of the rule of law? And by the way, taking students for political hostages, but that's another issue. And so here, are we speaking about a total lack of causality in the application of the regulation, because the regulation of the European Union says clearly that you need a sufficiently assessed risk, if you want. Here, they're not assessing anything. They're just assuming. So, totally disproportionate behavior on for an hypothetical, like infringement that never ever happened, and taking basically like sanctioning, like in a general cause, 180,000 students, and all that in the name of the rule of law. So I don't want to enter into academic debates, but if this is the rule of law, no thanks. I'd rather live without it. Nem köszönöm. I really don't want it. That's why, allow me to be provocative, I've been provocative for 15 minutes already, but I don't think the EU should even deal with the rule of law. First, because no one gave it a mandate. Second, because it's not well placed, because itself, they need to look at themselves in the mirror. Third, because they don't have the tools. Fourth, because they already politicize it to obscene levels. And if I want to be a bit more nuanced, because we still think that sometimes the EU job in the rule of law is not so bad and should be maintained, then just maybe a couple of suggestions. First, maybe to the future MEPs in the room. First, get rid of the conditionality. This is an exorbitant power given to people who never had a power before. If basically for 70 years you only had one plastic gun to enforce European law and suddenly you are given a nuclear bazooka, it's not going to end up well. And this is exactly what they are doing with Hungary today and no longer Poland, because Poland, of course, they confiscated 137 billion euros to Poland. But surprise, surprise, by art of legal magic, it was enough to change the government, and for this government to give only some very, very generic promises to basically get the money flowing again. This is a mockery. This is a mockery. It's worse, actually, it is financial blackmail. And if we want the EU to do something in the field of the rule of law, then please get it out of the political and ideological hands of the European Parliament and the European Commission. It should remain within the European Council, among the member states, and if possible, by absolute unanimity. Because this is the best guarantee I found to make sure that this rule of law that has been already very, very much prostituted is not going to be even more in that case. Thank you very much.
I look at the clock, time soon runs out. Thank you very much for both of your enlightening lectures. We've heard all of the important keywords, I think. Sovereignty, primacy of national constitutional law, even some aspects of constitutional identity, which we did not really go into, but have mentioned them. New and old democracies, postmodern statehood. Also, one thing that I want to add maybe to the Polish and Hungarian situation and how politically involved this whole rule of law field is, if we talked a lot about the dialogue between member state constitutional courts and the Court of Justice, and a German example came to mind, just thinking of the recent Polish one, when the so-called PSPP decision was issued in May 2020. Declaring ultra vires an act of the European Central Bank by the German Federal Constitutional Court, the European Commission has instituted infringement proceedings against Germany. And just to borrow from Rodrigo, surprise, surprise, the German government had sent the Commission a letter in which they promised they will do everything in their power to end up in a situation when the German Federal Constitutional Court no longer will have a competence to issue such a decision ever again. I'm just putting it out there. as food for thought for the lunch break, maybe. Thank you again very much for our presenters for the enlightening lectures, and we give them a round of applause.